Hola a todos y bienvenidos nuevamente al canal. Today we're diving into a crucial legal topic that affects every family, parental authority, or, as it's known in Venezuelan law, patria potestad. This isn't just about who makes the rules. It's a fundamental concept that defines the relationship between parents and their children. So, what exactly is parental authority? At its core, it's the set of duties and rights that parents have regarding their children. Venezuela's constitution, in Article 76, establishes a shared duty for parents to raise, train, educate, maintain, and assist their children. This constitutional duty is the bedrock of parental authority, the organic law for the protection of children and adolescents, often called LOPNNA, expands on this. It says parents have shared, equal, and undeniable duties to raise, educate, guard, supervise, and support their children materially, morally, and emotionally. These obligations are rooted in filiation, the legal parent-child relationship, not in marriage. This means that even in cases of divorce, separation, or if one parent loses their parental authority, these fundamental duties to the child persist. There are no exemptions. Consequently, children have a right to be cared for by their parents, to live in a family, to maintain personal relationships with both parents, and to have an adequate standard of living that ensures their full development. Parental authority is the mechanism that makes these rights a reality, and they don't disappear just because the parents are in conflict. Let's get more specific. Article 347 of the LOPNNA defines parental authority as the collection of rights and duties parents have over their children who are minors and unmarried. The main goal, the care, development, and comprehensive education of the child. This includes three key components: the responsibility of raising the child, representing the child in legal matters, and administering the child's property. It covers both personal and financial aspects. It's vital to understand that parental authority is an institution created primarily for the benefit of the child, not the parents. Its purpose is to guarantee the rights of children. As one legal scholar puts it, the philosophical basis of this institution is the benefit and protection of the minor, not the personal advantage of the parents. While some might see it as a two-way street of rights and duties, Venezuelan law is clear. Parental authority places obligations on the parents, not the children. The only duty LOPNNA places on children is to honor, respect, and obey their parents. As long as the parents' orders don't violate the child's rights and guarantees. Now, who holds and exercises this authority? The ownership or titularity of parental authority belongs to both parents. It doesn't matter if the child was born within a marriage, a stable de facto union, or any other type of relationship. Both parents share the exercise of this responsibility, meaning they act jointly in raising, representing, and managing their child's assets. But what happens when parents disagree? Article 349 of the LOPNNA states that parents must always act in the child's best interest. If they can't agree, they should try to decide what's most beneficial for the child, considering past situations. If they still can't find common ground, either parent or even the child, if they're an adolescent, can go to the Child and Adolescent Protection Court. This best interest of the child is a guiding principle in all decisions. It's meant to ensure the child's complete and harmonious development. While the law provides criteria, defining this best interest in practice can be complex. There are different schools of thought. A traditional view might define it by a strict top-down education, ignoring the child's own wishes. A more psychoanalytic view might equate it with the child's desires and preferences. The modern approach seeks a balance, weighing the parent's authority against the child's emotional needs and development. Even during a marital crisis like separation or divorce, the exercise of parental authority, in principle, remains joint. However, practical changes are inevitable, especially regarding daily care, since the parents no longer live together. There are exceptions, though. If a divorce is granted based on severe grounds, such as one spouse attempting to corrupt the other or their children, or severe addiction that makes life together impossible, the court will declare the extinction of parental authority for the at-fault spouse. They will lose their parental rights completely. This brings us to the concepts of privation and extinction of parental authority. When parents, through their actions or failures to act, undermine the core purpose of parental authority, the child's development, the state must intervene. This intervention can take the form of privation, which is temporary, or extinction, which is permanent. Ideally, a child should be under the parental authority of both parents. But when a child is in danger, it's better for the parent causing the harm to stop exercising their authority. Privation or deprivation is a temporary suspension. A judge can declare it if a parent is found guilty of one of the causes listed in Article 352 of the LOPNNA, like abuse, neglect, or setting a corrupting example. It's a sanction to punish parents who exercise their authority improperly. Importantly, economic hardship is never a sufficient cause for privation. After 2 years from the final court decision, the parent who was deprived of their authority can request its restitution. The judge will grant it if the parent can prove the original cause for privation no longer exists and that restoring their authority is in the child's best interest. The court will consider the opinions of the child, the other parent, and anyone else involved in the child's care. However, if a parent, after having their authority restored, relapses and commits another act that warrants privation, the authority is then extinguished. This is called reincidence. Extinction is definitive and permanent. The parent will not get another chance to exercise authority over that child. This isn't automatic. It requires a new court ruling. Besides reincidence, there are other causes for the extinction of parental authority. These are the child reaching the age of majority, the legal emancipation of the child, the death of a parent, or the legal consent for the child's adoption. In the first two cases, the child simply ages out of the system. In the case of a parent's death, the surviving parent continues to exercise full parental authority. If there is no surviving parent, or if they are unable to exercise their authority, the child will be placed with a substitute family. Understanding parental authority is crucial because it frames the legal and moral obligations that underpin the family structure. It's a system designed to protect the most vulnerable and ensure that every child has the opportunity for a healthy, full, and secure upbringing, guided by the principle of their best interest above all else. Thank you for watching. I hope this explanation has been clear and helpful. If you found this video informative, please give it a thumbs up, subscribe to the channel, and hit the notification bell so you don't miss our next deep dive into important legal topics. See you next time.